Welcome back everyone to the criminal trial process, looking at the different defences to criminal charges. Now, a word of caution, this is a longer video because there is a lot of detail, so I will try my best to get through it reasonably. So most defences revolve around the mens rea of a defence. Okay, and defences help achieve justice because it considers the accused actions surrounding the crime. Defences operate to justify the accused actions and therefore either to remove or reduce, as a partial defence, which we'll get into at the end of this video, their criminal culpability. If you think about the essential elements of a crime, which are being consciously involved in a prohibited conduct, you'll note the specific defences, if proven, operate to remove one of these two elements, therefore precluding the prosecution from proving their case beyond a reasonable doubt. For example, the defence of self-defence removed the mens rea of an element. If proven, clearly the accused intention was to defend themselves or a third party and not to commit the crime. A crime is an act or an omission that harms society that is punishable by the state. Accordingly, it is entirely just that if an accused has a justifiable reason for their behaviour, they should not be sanctioned by the state. Or at least in the interest of justice, they should receive a lesser sentence in the event of a partial defence, for example to murder, being established. So, a word of caution before we move ahead. With reference to strict liability offences such as speeding that do not require that intent is proved, they can only be successfully defended if the accused can prove that the actual act did not occur, as mens rea is completely irrelevant. So, defence has two broad types, the complete and the partial defence. So, we'll start off with complete defences and then we'll move to partial ones. So, it's important to note that partial defences do not apply to lesser charges such as assault. Accordingly, if an assault is provoked, the provocation will actually be a mitigating factor, that is, reduces the harshness for the judge or magistrate to consider on sentence, but it does not entitle the accused to being acquitted. So, complete defences. If successfully proven, the accused will be acquitted, that is, completely let off of all charges in the trial. So, mental illness. The onus of proving the defence is on the defendant, on the balance of probability. A key case for this is 19th century English case of Macnaghten, 1843 for those interested, which established the test for proving insanity. The defence must prove that the defendant did not understand the nature and quality of their act due to their diseased mind. Accordingly, the defence must prove that the defendant did not know what they were doing and/or that the defendant knew what they were doing but didn't understand that it was wrong. It could be difficult for a defendant to prove the requisite level of mental illness to satisfy this test. This led to legislative reform in New South Wales in 1974 and the creation of the partial defence of diminished responsibility. Don't worry, more on this later. If proven mental illness, this defence results in the accused being acquitted, because the law does not hold people who suffer severe mental illness responsible for their actions. However, they are not free to go. Instead, they are held in a mental institution. The length of the defendant's stay in the mental institution is indefinite and could well be much longer than the jail sentence they may have received if they had been proven guilty of the crime. The onus of proving that the accused did not act in self-defence, if the defence is waived, is actually on the prosecution according to the Crimes Act of 1900. New South Wales, Division 3. The leading case is this decision of the High Court in Zacevic in 1987. The defendant must prove that they believed, which is subjective, upon reasonable grounds, which is objective, that it was necessary in self-defence to do what they did either in defence of themselves, their property, or a third party. Self-defence is now codified in the Crimes Act of 1900. If proven, it results in the accused being acquitted because the law has been satisfied that the defendant's actions were justified. Now, necessity is another interesting one. The onus of proving this defence is on the defendant. So the defendant must here prove that the crime was committed only to prevent the commission of a more serious crime. That is to say, the defendant must genuinely believe that their actions were necessary and they must not be out of proportion to the harm that they were trying to avoid occurring. And it only operates when other defences do not apply. Now, somewhat related to this is duress. Now, a defendant can be acquitted if they can show that they acted against their will under unlawful pressure, also known as duress. Now, the defendant must prove this. The defendant must also prove that they committed the crime against their own free will because of genuine threat or intimidation. For example, their life or someone else's life was in peril. So, someone holding a gun to your head or to someone else's head to do something. It cannot apply to murder or to manslaughter charges. Now, quite importantly, R versus Williamson in 1972, the defendant disposed of a body while under the threat of death. Now, this threat was upheld to constitute duress. Whether you agree with it or not, I don't know, but it is an important case to know. Now, consent. This can be a complete defence for some crimes if the accused can show the victim freely consented to the act in question. For example, being accused of sexual assault. This cannot be used for crimes such as murder. The onus for proving this is on the defendant. In most commonly raised sexual assault cases, the term assault implies an absence of consent. So this is a really tricky one. Now, involuntary behaviour, also known as automatism, relates to the mens rea of the accused. Now, this defence suggests that the accused action was not voluntary and could not be controlled. The mens rea cannot be established under this defence. So the typical examples include sleepwalking, where someone's bodily actions, have no conscious origin, and diabetic hypoglycemia, where the accused's body becomes uncontrollable, almost in a fit-like state. So some really important cases there. You can have a look at the Attorney General versus Whelan in 1934. Also, Moffat versus R in 1977. This case was an appeal, and Moffat was found guilty of the manslaughter, not murder of his wife, after it was accepted that her manner and language provoked him into fatally striking her with a piece of pipe. Very interesting. You also have over here on the right hand side the trial of James Hadfield, 1800, and the trial of Daniel McNaughton, which we had a little look at before. Now, partial defences operate to mitigate, that is, reduce, although not completely excuse or justify, the defendant's behaviour. So, this is used to downgrade certain charges, such as murder to manslaughter. So, mitigating circumstances, this is the definition that caused them to carry out the act. This may reduce the sentence, very rarely will acquit the accused. So a good example again is murder to manslaughter. So provocation. The onus of proving provocation is on the defendant, and they must prove that their actions were directly provoked by the victim on an objective test. That is to say that the victim's actions would have caused any reasonable person to act in a like matter. The emphasis there is on a reasonable person. So, substantial impairment of responsibility. This is known as diminished responsibility, and the onus of proving this defence is on the defendant. If it is a statutory defence, the defendant must prove that they were suffering from an abnormality of the mind, quote unquote, at the time of the offence, which is, quote, substantially impaired their mental responsibility, unquote. This defense cannot be relied upon to excuse the accused if they are under the influence of alcohol or other mind-altering drugs. Now, a really good example, I know it's another old one, is R versus Byrne. The accused was a sexual psychopath with violent sexual desires that he could not control. Most of the time he was considered to be normal, but the occasional episodes had led him to be homicidal in the past. In this particular case, the court ruled that the charge of murder should be reduced to manslaughter. Okay, we're at the end. Thanks for joining in. You probably want to listen to that more than once. That is by no means exhaustive in its description, but I hope that gives you a good overview. Thanks for joining us.